Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Welcome to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On March 3rd, the court decided United States v. Zubaydah. Joining today to discuss this case is Kate Comerford Todd, Managing Partner at Ellis George Cipollone in Washington, D.C. Listeners may remember Ms. Todd joined earlier in the term to discuss arguments in this case. We welcome her today for the decision.
On March 3rd, the Supreme Court issued its opinion in United States v. Zubaydah, involving the state secrets privilege on a Guantanamo Bay detainee's discovery application under 28 U.S.C. Section 1782. The array of separate writings and incomplete joining of the primary opinion have all the earmarks of a case decided later in the term. This is March. Justice Breyer wrote the opinion of the court, with a few exceptions, which we'll get to in a moment. The majority, primarily comprising Justice Breyer and the Chief Justice and Justices Kagan, Kavanaugh, and Barrett, necessarily reaffirmed the existence of the state secrets privilege, invoked United States v. Reynolds, and outlined a framework of sorts for the court's analysis. After a formal claim of privilege is lodged by the head of the department which has control over the matter, after actual personal consideration by that officer, first, the court itself must determine whether the circumstances are appropriate for the claim of privilege, with deference. Second, the court will analyze the showing of necessity made by the parties seeking disclosure. The majority makes clear there is not a pure weighing of interests by its acknowledgement that the privilege could apply even where there is a strong showing of necessity. But there also appears to be the need for some probing by the court into the government's claim, even if the need for information is ultimately found to be dubious. In this case, the court does look to the government's reasons for invoking the privilege. This is a point Justice Thomas takes issue with. The majority also adopted the government's view that information in the public domain may nonetheless be protected, recognized here that the CIA had steadfastly refused to confirm or deny the accuracy of public speculation about its cooperation with Poland, and held that the CIA director's declaration established that there is a reasonable danger that compulsion of the evidence at issue will expose matters which, in the interest of national security, should not be divulged. The court rejected the Ninth Circuit's notion that because the relevant witnesses had been contractors with the government, the privilege would not apply to their testimony. And ultimately, the court, this time 6-3 with Justice Breyer, the Chief Justice, and Justices Thomas, Alito, Kavanaugh, and Barrett, reversed the Ninth Circuit and remanded with instructions to dismiss the application for discovery under Section 1782. Justice Breyer was joined only by the Chief Justice and Justice Kagan in drawing on an admittedly rough analogy to the FOIA context to underscore that there is a distinction between something that has been already become public and being officially acknowledged by the relevant agency. And Justice Breyer was joined only by the Chief Justice and Justices Kavanaugh and Barrett for his reasoning as to why the discovery application must be dismissed altogether, rejecting the need for in-camera review, finding the government's affidavits sufficient and Zubaydah's need low, and rejecting the notion that a protective order or code names limitations could work to safely permit some discovery. For ease of road mapping, I'm going to take the separate writings out of order of seniority. Justice Kagan dissented as to the court's decision to instruct dismissal. She would have remanded to the district court to allow Zubaydah to amend his request to remove all Poland-specific references so that he could obtain information about his treatment during the relevant time period, presumably in whatever country it took place. Justice Kavanaugh, joined by Justice Barrett, wrote separately in an attempt to clarify his view of how the Reynolds process should work, starting with a threshold judicial inquiry that he says is not demanding about whether the circumstances indicate a reasonable possibility that state secrets are involved, then moving to the issue of need for the information, and finally, if that need is strong, a court must engage in deeper consideration of the government's claim. If it is dubious, no further inquiry is made to uphold the privilege. Justice Thomas, joined by Justice Alito, wrote a decision concurring in part and concurring in the judgment, thus creating the majority to dismiss the discovery application outright. Factually, he took the time to recount the record support for Zubaydah's terrorist activity. Substantively, he diverged from the majority in how a court should approach a claim of state secrets privilege, interpreting Reynolds to demand a simpler approach that places the necessity question first, before any judicial probing of a state secrets privilege claim, such that upon a demonstration of only dubious need, the court need probe no further to uphold the privilege. Finally, Justice Gorsuch, joined by Justice Sotomayor, wrote a hot dissent that characterized the government's interest as the desire to be shielded from some, quote, further modest measure of embarrassment, unquote. It is a lengthy and frankly scathing rebuke of the government's invocation of the privilege in this case and deference to the executive in this area more generally, and it chronicles publicly available information about Zubaydah's treatment. There is much Justice Gorsuch finds concerning about what he sees as the overclassification of information and the temptations to cover up government wrongdoing. This leads him to what Justice Thomas describes as a probing, effectively de novo review of the government's assertion of national security interests in this case, and Justice Gorsuch's conclusion that, quote, we should not let shame obscure our vision, unquote, the we, presumably about his colleagues on the court. What are the quick takeaways? The state secrets privilege is alive and well and applies in the Section 1782 context. Even where the need for the information is great, a proper claim of privilege will prevent the information's disclosure. In-camera review will not always be required to uphold the privilege, and the government can properly invoke the privilege as to testimony of contractors. What was an answer? Justice Breyer left open the possibility that Zubaydah may be able to make different discovery requests in the future that could avoid application of the privilege. The court also implicitly left open the possibility that information denied to a foreign government via the diplomatic MLAP process could nonetheless be required to be provided to a private applicant under Section 1782. The precise amount a court needs to probe the government's reasoning during which stage of analyzing the state secrets privilege claim is less than clear. That's what Justice Kavanaugh's separate writing reveals. And as I noted after argument, the government has informed the court it will permit Zubaydah to offer his own statement on his treatment consistent with its review process. What that process will yield remains to be seen.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.